afternoon and welcome to this latest residential conveyancing forum. Apologies for the rather weird entry, but something's happened to our system, and rather than keeping you all waiting outside in the virtual hallway, you were able to sneak in when our back was turned. But very grateful to see you all here again, and for such a great turnout and for the feedback we've been receiving. No more from me, Ian. Let's get on with the topics today and the things that are of use and for people to talk about.
Yeah, great. Thanks very much, Robert. And a massive thank you to Stewart Title for inviting us along today, as usual, and for organising these events. Do please speak to Robert, Freddie, Teddy and the team at Stewart Title if you have any sort of requirements relating to your title indemnity insurance. Be aware that they have an online platform that can create bespoke policies for you. It's often worth having a chat and a catch up just to see what's new or what's happening. So do take the opportunity to speak to Robert and the team if necessary. What I'm going to do today is look at lots of interesting topics. For some reason we've got, and Robert, you might be able to explain this, but we've got some marketing material for the Society of Licensed Conveyancers, and quite right too. A great organisation that Robert and I do quite a lot of work with. Again, just as I was saying with Stewart Title, well worth having a look at what the Society of Licensed Conveyancers are about and what they can do for you. So again, some material there from Anya and the Society of Licensed Conveyancers for you to have a look at. So I'll just quickly skip through those.
Sorry to interrupt. Simon is here from...
Ah, right. Right. So, Simon, I've stolen your thunder. 1,000 apologies. And I'll go back and allow you to say whatever you need to say with regard to your slide. Sorry about that, Simon.
No problem, Ian. Thanks to Rob and Stewart Title for inviting us to this. We obviously do a fair amount of work with both Stewart and Ian as well. Ian's been very helpful with the documentation that we've put in place for our members for the Building Safety Act. I think with a lot of members, that means they're still not going to do the work, but that's absolutely fine. At least they're informed about it. If we just go to the next slide, just a quick bit about the Society of Licensed Conveyancers. I will run through these very quickly. They were established in February 1988, which makes me feel old because I would be about 8 at the time. But basically, we're the representative body for licensed conveyancers and are distinct and independent of the Council of Licensed Conveyancers. We're governed by elected board of directors, and in 2013, we opened up membership to solicitors and legal executives to join as associates, and also students can join as well. The benefits of memberships: free CPD webinars, a free annual conference, which we also have a rather well-attended dinner afterwards. That does tend to go on until the early hours of the morning. A library of guides, which we'll look at a little bit later, but they really are client guides, and we've also issued some conveyancer guides as well. We help our members with lender panel issues, be that getting on the lender panel issues or some any issues that they might have with the lenders that come across. We've been tackling bridging finance recently as well, and have had some success at that. We have a professional indemnity offer for our members as well, which gives them a discount on their annual premium if they're members, and also a cyber insurance policy that's tied with that as well. We then issue a quarterly magazine called The Property Lawyer, which just gives out some little bits and pieces that we've been doing over the last quarter, and it'll have any information guides and topics that we feel that are relevant within that as well. Again, a little bit for more on the free guides here. They are exclusively used for SLC members. They are great in terms of the guidance that they give to the clients. They range from anything from septic tanks up to insurance. There's about 30, I think, client guides at the moment And the latest one that's about to come out is both to clients and conveyancers on e-signatures and how they can be adopted as well. There's a list of the client guides. They are all regularly updated as well. So if something changes, they will be updated and they will be reissued to our members. And they can all be used either within your to send out to your clients. You can use them on your website as well. There's no sort of limitations on that once you become a member. And then finally, just how to join and the costs of it. There are also discounts as well for firms that have a few more licensed conveyancers, and the email or the telephone number and the website as well. Basically, I will leave it there and let Ian get on with the raft of information that I know he's going to impart on you. He seems a bit happier than the other day when we spoke.
No, I was just saying, so you were muted, Ian, and I was, as you've come to me, just mention another benefit for SLC members is that we do have a link with them, and members can receive either 20% commission or 20% discount to be passed on to clients on indemnity policies ordered through the joint Stewart SLC portal. So you can see from that, you can save very quickly the cost of membership there, just on that alone.
Thanks for that, Robert. Yes, sorry, I didn't realise I was muted. Simon, what I was going to say was, you mentioned the guidance for members on the BSA. I've just revised the report on title and information when acting for sellers and buyers due to the Law Society guidance. So I'll be sharing that with Anya for distribution to members. And again, a massive thank you to Simon and the team for sort of allowing me to share what little knowledge I have of the BSA with members. But there are some changes given what the Law Society guidance has said. And just on that point, Zara, hi Zara, has said, I think just a question to you, Simon, what do you make of the updated TA forms? Have you had a look at them, Simon? I have, but Zara's asking, were the CLC consulted by the Law Society? Would you know that, Simon, or not?
From the top of my head, I can't remember that we were consulted on the latest ones. Although, having said that, we've had a lot of going and forwards on a number of things with them over the last few months. So, I mean, in general, we do get consulted by even the Law Society on these things, and they have taken a more collaborative approach with us over the last sort of well, since COVID really, when we worked on the joint riders and information forms since then. So yeah, I still think there's a lot of updating for that's actually needed in the TA forms, to be perfectly honest.
Yeah, without a doubt. I've seen them, done some work on it, Simon, and yeah, you're quite right. And what I would have planned to do was to do something potentially towards the end of the month with regard to some guidance relating to the TA form. So perhaps, Zara, we can look at that on another occasion at the next forum. I think that might be an appropriate time. Simon, thanks very much for that. That's great. Are you going to stick with us, Simon, or have you got other things to do?
Oh, yeah, no, I'll stick with you.
Lovely. So if anyone has any questions of Simon, again, the chat facility is a great way of doing it. As Simon mentioned, that I've got loads of different things to talk about today, including some case law that I've been working on over the weekend and some topics to look at. But remember, if anyone has any burning topics that they'd like to explore during today, more than welcome to deal with that as and when we progress. So I always mention useful websites. On the issue of Property Law UK, the March edition is due out. We've got, I think, 7 case reports, lots of interesting articles, etc. The March edition was to be a BSA special edition that was going out free. In fact, we'll push that back to April because we're waiting for some information from Tanfield Chambers that will go into that. So if anyone's interested in seeing Property Law UK, as I say, the April edition will be a free edition. And I think if you want to subscribe to Property Law UK, from memory, I think we do offer a discount to CLC members. All of those websites are useful. 3 Stone Buildings, there's a barrister there called Alan Tunkel that devised a co-ownership questionnaire years ago. I think Alan's retired now, to be honest with you, but his questionnaire should be on the website. If it isn't, let me know and I can send you a copy of it. The other thing that's worth having a look at is the Leasehold Knowledge Partnership that a lot of practitioners are not aware of. City of London Law Society Land Law Committee has done some work on the new code for exchanging contracts that the Law Society is currently consulting with, and the Association of Residential Managing Agents has some useful information about LPE1s and guidance relating to leasehold ownership. They used to have on that site some information about estate rent charges, which has been taken down. I don't know why. Legal Ombudsman site's really interesting with regard to some issues relating to SDLT, which is one of the things I want to talk about today, which leads me on to topics. So, new Law Society guidance on the BSA. Question, Simon touched on a point there. How many people now that weren't dealing with BSA related transactions have now read the Law Society guidance and are now saying, yeah, we're ready to take it on board? Anybody? What do we think? I've got my own view. I'd be very interested to see if anyone has had a change of heart as a consequence of the Law Society guidance. Zara's saying still not allowed. I'm assuming that's an insurance issue, Zara. Anybody else, though? Has anyone read the guidance? Anyone read the guidance? Zara's got a hand up. Zara, if you can allow your microphone to come on, that's fine. And I'm quite happy to hear from you, Zara. The interesting thing about the Law Society guidance, if you haven't read it, is that it mentions two things, which, to be brutally honest, I didn't think were particularly important. One was the developer's remediation contract. Remember, the idea of developers, landlords, builders, writing to the government to say, if there is remediation work for relevant defects, then we'll pay for it. Now, I didn't give that an awful lot of credibility on the basis that there wasn't any mechanism to allow a leaseholder to enforce that contract. And it isn't really a contract anyway. It's sort of a letter of intent, in my view. And therefore, let's assume one of the big house builders commits to it and then decides it can't or it won't. I don't think a leaseholder would have a right of action against that developer. And that's why I wasn't too keen to sort of promote its use. The Law Society guidance says that you must check with the seller if there is a contract in existence and highlight to the client the benefit of that contract, the benefit being, this is the Law Society, not me, that you can rely on that contract to ensure that you're not liable as a leaseholder for the cost of remediation for relevant defects. The other thing, yes, hi Zara, go on.
Hi, I was just going to chip in. I think they are living in cuckoo land, thinking that the developers will come in and remediate all the stuff that they've done, because, you know, it's difficult enough just to get them back in to fix a tap, let alone fix a whole building. New build warranties aren't worth the paper they're written on, unfortunately. And I think more needs to be done to raise awareness that these new build warranties, you know, are very, very difficult for people to claim on. Yeah,
they're flimsy, aren't they? Yeah. And I mean, the other thing is, right, that even if a developer has the intention to be honourable and to do that which is said, you could have a situation where the developer doesn't have the money to do it. So, you know, if a developer signs, as I understand it, the developer remediation contract, in other words, the letter sent into government saying we're going to stand on for remediation costs for relevant defects in connection with this building or in connection with the buildings that we own, what is the position if that developer actually can't do it? Okay, is the government going to say, well, because they've signed the remediation contract, we'll step into their shoes and pay for it? I think highly unlikely. So we've got, as Zara says, this vicious circle where ultimately, where a landlord becomes insolvent, leaseholders at the end of the day are at some point going to end up putting the bill, meeting the cost. Got to be, because, you know, landlord becomes insolvent, trustee in bankruptcy, liquidator isn't going to meet remediation costs, despite the fact the Building Safety Act does create a sort of pathway for insolvency practitioners to get their hands on funds that hopefully will meet remediation costs. There's no guarantee that that is the case. Anyway, I go back to the question, has anyone actually read the guidance? And has anyone said that, right, having read the guidance, we're now happy to take this work on? Can I tell you that in every conference I've spoken at, every webinar I've delivered since the guidance has come out, including webinars on the guidance, I haven't had anyone say to me, yeah, as a result of this, the position is now crystal clear, we can act. What I've had is the vast majority of people being critical of the guidance and saying, we're not sure, we're still not sure. In fact, we're even less sure, having read the guidance, than we were before. And so, unfortunately, I don't think it has done which everybody hoped. To be honest, I don't think it could ever do. The Act is so complicated, the regulations even more complex, that it's impossible for there to be a framework or a guide to enable you to act when acting for sellers. I repeat, two things Zara has just mentioned. There is a book that's due out any day. Zara will promise during March it will be launched and published by the Law Society. I haven't checked. It's one of the things I've got to do with the Law Society this week, to check when it comes out. And we still have a series of flowcharts and guides for practitioners which can assist with regard to working on a sale or a purchase. But unfortunately, you do need to scope your retainer very carefully and very robustly. And you've also got to explain to clients the consequences of the retainer being scoped. In other words, and again, just as I was saying to Simon, being working on this over the weekend, you've got to say to your client, I cannot, hand on heart, confirm definitively that this is a relevant building or this is a higher risk building, number one. Can't confirm that. The only thing I can say is if a higher risk building has been registered with the building safety regulator, then in all probability it is a higher risk building and therefore is a relevant building. I cannot confirm what a leaseholder is telling me in a leaseholder deed of certificate as to their ownership or occupation on the 14th of February 2022, other than for saying where a leaseholder is prepared to admit in a leaseholder deed of certificate that the lease is non-qualifying, that the lease may well be non-qualifying, meaning that you don't have all the protection that Schedule 8 of the Building Safety Act provides. The other thing that I think you need to say is you can't guarantee the content of a landlord certificate, whether the information is correct or otherwise. You can't confirm some information in a leaseholder deed of certificate. As a consequence of that, you can't confirm in most cases whether a lease is a qualifying lease or not. Important that you understand that as far as the Building Safety Act is concerned and Schedule 8 is concerned, there is some protection in Schedule 8 for all leaseholders. Anyone that has a residential long lease, whether it's qualifying or not, and any commercial tenant, a landlord cannot transmit remediation costs for relevant defects where the original work was undertaken by the landlord or an associate of the landlord. So in those circumstances, no matter what sort of tenant you are, if you're in a relevant building, you're protected from landlord's remediation costs where the landlord or an associate of the landlord did the work in the first place. But that's the only real thing you can say with a degree of certainty. So, one, difficult to say whether a lease is protected or not. Difficult to say whether when a lease is sold in the future or remortgaged in the future, whether buyer is going to be happy with the information that's produced or happy with the admission or denial that this is a qualifying lease. So there are all manner of problems relating to the Law Society guidance. And as I say, it probably raises more questions than answers. The other thing that it does is it requires you to ask a seller or a buyer, if you're acting for either, if they know the status of the building in which the property is situated. And the Law Society guidance also highlights the fact that where a landlord is making a claim to government for a grant, that's a very important point, because again, that confirms that all things being equal, the landlord will be recovering costs that could be transmitted into service charge from a third party. The problem I would say with that is just because you've made an application for a grant doesn't mean that the application will succeed. Therefore, I concede that where a grant has been applied for and a grant is available, and you've got evidence to confirm that, that's good news. The simple fact that an application has been made for a grant is neither good news or bad news. It depends on the application and depends on whether that particular pot of money is available to landlords. So do have a look at it. As I say, don't hold your breath that it's going to give you a magic fix. I think if you're already doing BSA related work, there may be some comfort in what the Law Society is saying that may enable you to continue to act and be a little happier. But that's about as good as I think it gets. The next thing I want to talk about is some case law. And this is something I've been working on today. And this is concerning, as I mentioned on the slide there, dispensation with the need to consult. Now, there's a number of important points that I want to make with regard to this case law. The first is that the Building Safety Act does provide that you can't ask for dispensation relating to consultation in connection with work for relevant defects under the Building Safety Act. So you can't do that, unfortunately. Okay, there is a bar on that provision. The case that I want to take you to is a case, as I say, I've just been working on over the weekend and this morning, which deals with this issue of dispensation. And I'll just give you the full citation on it. Here we go. RM Residential against Westacre Estates Limited. 2024 decision UK UT 56. Upper Tribunal decision. And what you had was a property in Cirencester that was mixed use. The landlord owned the commercial part of the building, which were on the ground floor. And there were 6 residential units on the first and second floors. The landlord purchased the building in December 2020 and only completed registration in January 2022. So the first thing that the tribunal had to consider was, can a landlord who has completed the purchase of a property but has not been registered as proprietor of that property deal with residential leasehold management issues in the intervening period? In other words, can the landlord seek an order to dispense with the need to consult, notwithstanding the fact the landlord was not registered proprietor at the time? Surprise, surprise, the tribunal said, yes, he can. He has an equitable interest. For our purposes, he or she is the landlord for the purposes of residential leasehold management. Nothing too exciting in that, to be honest with you, but again, a useful sort of reminder of that position if it were required. Okay, now, the buyer buys the building and gets an expert's report looking at the state and condition of the property and identifies that there were cracks in mortar joints and stones, meaning there was movement in the property that required urgent attention, described by the tribunal as urgent restraint. As an aside, that would be potentially a defect that would be a relevant defect for BSA purposes, because that defect generates a risk of collapse of the building. Remember, relevant defects relating to fire safety, or defects relating to or potentially generating a risk of collapse of the building. So, because this is urgent work, and because the consequences of a lack of attention to this work would be catastrophic, the appellant landlord gets on with the work immediately, carries out the majority of the work, which was completed in September 2021, a year before the landlord was registered as proprietor. The landlord hadn't consulted at all with leaseholders. So not only was there an attempt to comply which failed, there was no attempt at all. Landlord simply dives into this urgent work and gets it done. It then seeks consent from the first tier tribunal under section 20ZA of the 85 Act for dispensation from the statutory requirement to consult. So landlord loses at first tier tribunal and appeals to upper tribunal. And what we've got is an examination of the consultation dispensation process by the upper tribunal, which stated that the 85 Act and the Service Charge Consultation Requirements Regulations of 2003 created a statutory process for tenants to be consulted before major works were undertaken, where leaseholders would be required to meet the cost of those works. The upper tribunal emphasised that the Act gave first tier tribunal a discretion to dispense with statutory requirements, and emphasised that discretion was dependent on facts. But the ethos behind the legislation and the regulations was to ensure that tenants were protected from paying for inappropriate works or paying more than would be appropriate when entertaining an application under section 20ZA1. So the tribunal had to focus in on to what extent leaseholders or tenants were prejudiced as a consequence of the failure. Now, that is an old case. You'll remember Dejan Investments against Benson, 2013 case, which was the case on that issue. Was there prejudice? And remember what Dejan said is the fact that leaseholders were not consulted had the potential to be prejudice in itself. So in this case, the upper tribunal said that consultation requirements were not an end to themselves, and a failure to consult was not something that generated automatic punishment. Interesting. On many occasions, said the tribunal, the urgency of work would be such that a landlord, whilst acting in the best interest of the tenant, went ahead without going through the consultation process. And again, nothing new in that. There was a recent case, and I've got a note of it here, Holding and Management Solitaire Limited against leaseholders of Sovereign View, 2023 decision that confirmed all of those points. The sort of prejudice that would have a bearing on the first tier tribunal's thinking in exercising its discretion would be where the tenants could show that they would have been able to suggest a better or cheaper way of doing things. So this moves away from Dejan and says, well, no, a lack of consultation per se is not necessarily prejudice. Prejudice is likely to arise if the leaseholders had been consulted. They could have revealed a better way of doing work or a cheaper way of doing work. And again, the tribunal looked at another case called Marshall against Northumberland and Durham Property Trust Limited, 2022 decision. So very, very interesting case, basically saying that prejudice could be provided where leaseholders could show, had they been consulted, there was a better way of doing work or a cheaper way of doing work. So again, I think if you're acting for leaseholders who are challenging an application to dispense with consultation, you've got the key words and the key evidence that you're going to need to submit to show that it was unreasonable to dispense with consultation. And if you're acting for a landlord, you've got to show that there wasn't really any other alternative with regard to what needed to be done and at what cost, and that the urgency relating to the work and the significance and importance of the work was such that it was in the best interests of leaseholders to get on with it rather than delay and go through the consultation process. So a question to everyone who's doing leasehold work: has anyone encountered a situation where an application has been made to dispense? And has anyone encountered a situation where it's been made after the event? So I've encountered it in circumstances where a landlord wanted to do work. It wasn't that urgent that it needed doing straight away, and the landlord was worried about failing to consult, so asked a tribunal first. But I've never seen a case where a landlord has simply done the work and then said, right, I want to get an order from you to dispense with the need to consult. I've always regarded that as being a fairly dangerous course of action. This case sort of highlights that perhaps it's not quite as dangerous as I thought. Again, let's just have a look at this. Zara says LP1 packs are muddy at best, just been presented with a 5-year plan to increase charge by a resident-run company. Yeah, a lot of LP1s are entirely unsatisfactory, and Zara and indeed everyone else do watch, because the Association of Residential Managing Agents encourages landlords and managing agents to put disclaimers in LPE1s. Yes, Sue, sorry about that. Thanks for that, Zara. Sue, can we have Sue's microphone on, please, and fire away, Sue? Are we allowing her to do that? That'd be great, please, if we could. Thank you. If we can allow Sue access. While I'm waiting for that, I just want to show...
I've got it.
Hi, Sue. Yes, hi, Sue.
Hi. It's kind of... it's on topic, but it's kind of a bit different. The only notice of dispensation that I've had is the property was, the landlord was the local authority, and of course, as you know, they've got different requirements. There's different requirements for a local authority when it comes to notice. We got a notice requiring dispensation because they had failed to advertise in the European, you know, they have to advertise, don't they? Because they're a public authority. And and they hadn't done that, so which, you know, just goes to show that, you know, sometimes you need to really know what you're doing in these in these notices, etc. But that's the only time I've come across a dispensation thing.
And Sue, while you're on, have you read the Law Society guidance on the BSA or not?
I haven't.
No, most people haven't, to be honest with you. And as I say, you know, I know we're all busy people. If you've got the time, have a look at it. But if you do, I don't think it's, as I say, the magic fix that people's thought about. No. Okay. Thanks for that. Thank you, Sue. That was great. Just before we talk about car parking, another case that I've just been dealing with is a case called Brown against Ridley, a 2024 decision concerning adverse possession and application for adverse possession. And again, another case where there was an argument about a freeholder claiming neighbour encroachment. And the issue before the tribunal is, did you have a reasonable belief that the land belonged to you? And this case of Ridley and Brown is really interesting, because what the court was having to think about and what the tribunal was having to think about was, do you have to have a reasonable belief for a 10-year period immediately before you apply for adverse possession? Or can you have a 10-year period of reasonable belief that the land belongs to you? And as long as you've got that 10-year period, does it matter when you make a claim for adverse possession? And what was decided in this case was that at first-tier tribunal, the applicants had been in exclusive possession of the disputed land since their purchase of the property, reasonably believing it to be theirs, until the date of application. And the judge said that what the legislation and regulations mean is that you need a 10-year period when you had a reasonable belief that the land belonged to you, and it didn't matter that that ended on or close to the date of application. And he said, even if I get that wrong, you must have a period of grace. Because if you believe the land belongs to you, why would you make a claim for adverse possession in the first place? So there was some sense in what the judge was saying in that case. So the matter then goes to the upper tribunal. And the upper tribunal said that if we look at the words in the legislation, we've got to be satisfied that the applicant had a reasonable belief that could be demonstrated in any 10-year period. Because an application for registration for adverse possession is ordinarily made after the applicant realises they don't own the registered title. But from that point of realisation, they will then be unable to demonstrate that they had a reasonable belief in their ownership. And they have to have that to exist on the date of application. So the upper tribunal said allowing a grace period between the end of that period of reasonable belief and the making of an application for registration was an answer. It wasn't really supported by what the Act and legislation said. It created yet further uncertainty. So how long would be a reasonable grace period, and what counts as prompt action being taken to register? Parliament couldn't have intended the reasonable belief condition to have operated in a way that allowed an applicant a period of time. So the tribunal said that we're not going to overturn the first-tier tribunal decision, but we're not going to endorse what was said about this argument that there was a reasonable grace period. In other words, suggesting that all that was necessary is that you had a reasonable belief that the land belonged to you for a period of 10 years. So really interesting case, that one. Hayley, hi Hayley, question. A BSA inquiry. So where property was owned by a son and mother, it was the son's only property, but the mother's owned small shares in 4 of the properties. We're of the lease wouldn't qualify because the mother wouldn't meet the requirements. Hayley, I think I've got the answer to this question, which is a miracle, but here we go. If they are co-owners, then either one of them can sign a leaseholder deed of certificate. And the opinion seems to be from a number of different council that if the leaseholder who signs the leaseholder deed of certificate only owned this property and no other as of the 14th of February, and it was their principal home, or owned no more than this and 2 other dwellings in the United Kingdom, all other things being equal, they could sign a leaseholder deed of certificate verifying this was a qualifying lease, even though a fellow co-owner could not have executed a leaseholder deed of certificate to that effect. Does that make sense, Hayley? So it seems to be, which runs contrary to logic, that if you have co-owners and one of them meets the criteria of, is it section 117 or 119 of the Act with regard to ownership or occupation as of the 14th of February 2022, you get them to sign the leaseholder deed of certificate and you're all right. Now, Hayley, if you want, I can dig out who's told me that that's the position, but I'm fairly confident that is the position. Don't know if anyone else has got any views with regard to Hayley's question. Yeah, the other interesting things, Zara and Hayley, on the Building Safety Act is that I'm dealing with 3 matters now where, how about this? One leaseholder owns a lease in the building, but also owns the freehold. I've got one situation where there's a block of flats with 100 leaseholders, one of whom owns a flat and owns the freehold to the block, meaning that the building is not a relevant building, it's leaseholder owned. Now, if you look at the Act, it refers to leaseholder owned in the plural, but I think it's the regulations and the guidance that refers to the fact that it can be singular or plural. And then I don't know whether it was this forum, another forum I dealt with, someone referred to one of the interpretation acts that says singular includes plural and vice versa. Yeah, and Zara says, I was being asked the same question in regard to deceased owners. Is the executor the leaseholder if the person died before the 14th of February 2022? And who is the owner if the leaseholder died afterwards? Well, the position seems to be that an executor can execute a leaseholder deed of certificate. Now, I think this is confirmed in the government guidance, and there is a decision of the first tier tribunal that says you can take into account government guidance in interpreting the BSA, but you can't take into consideration any ministerial comment or statements. And I think the other point is, and this is the interesting one, Zara, if an executor executes a leaseholder deed of certificate, does the executor, with regard to section 119, does he or she state his position with regard to ownership of flats or apartments, or does he or she specify the status of the deceased? And it seems to me that logic says you specify the status of the deceased. But I think what Zara says is an interesting one. So if the executor is a leaseholder, if the executor is an executor of a leaseholder who died before the 14th of February 2022, then the leaseholder could not be said to be the owner, and it being the principal. You can't have a principal home of the deceased when the deceased is no longer a person as of the 14th of February. So that would suggest, Zara, that the executor completes the leaseholder deed of certificate on the basis of their status, doesn't it? But again, that hasn't been tested by tribunal. I think it's mentioned in guidance, and again, Andrew Butler Casey of Tanfield Chambers has raised the point. I think he deals with it in one of his papers that's on the website of Tanfield Chambers. If the leaseholder died afterwards, after the 14th of February 2022, but was alive as of the 14th of February 2022, then logic would suggest, Zara, that you complete as an executor the deceased status of that as of that date. Okay, Haley, drop me a note if you can, please, via email, and I'll share with you what I confirm about the BSA. And again, if anyone else wants to know about that, let me know. In fact, what we might do is share with everyone that attends today. Great. Again, anyone got any more topics to look at before I start having a look at some of the things I want to talk about? Right. So, freeholder and leaseholder reform bill. Go on, Zara. Michael Gove reported in the Times saying we're going to have to walk away from this a bit and water it down on the basis that our supporters who are funding us, namely landlords, etc., don't like it. No, not abandon, Zara. I think there's an article in the Sunday Times where Michael Gove is saying we need to backtrack a bit because we've been consulted by landlords who are saying there's no way that you can dispense with ground rents completely. And I think in the Times they were saying something about capping ground rents. I think from memory, but there's certainly an article in the Sunday Times. I think it's reported on LinkedIn as well, Zara, from memory. The freeholder and leasehold reform bill is interesting. The reform of leasehold is really interesting, and I didn't realise until the weekend just how much pressure government was under from landlords. I knew there was pressure, not in its entirety, as are not abandoned in its entirety. I think what we've got is a watering down. Yeah, I think that was mentioned, Zara, about buying out like the freehold rent charges, not just by statutory extension. And I think that didn't find favour at all. But thanks for that, Zara. Next thing on my list, car parking easements and the right to park. Again, really interesting. The right to park can be an easement, but remember, for it to be an easement, one, there has to be 2 parcels of land. 2, the right that is granted must not give exclusivity to the owner of the dominant tenement. So the owner of the servient tenement must retain a degree of control over the servient land. And in addition to that, the easement must not put the owner of the servient land to expense. The other thing with regard to car parking is where you are given exclusivity to park and the car parking is for business purposes. There's been a few cases where the agreement has amounted to a tenancy that's been 54 Act protected. So with regard to car parking, generally speaking, you want the landlord to retain control over repair and maintenance of the area of servient land over which the right is granted. You want the owner of the servient land to reserve the right to allocate alternative bays within the car parking to the owner of the dominant tenement. And you also should ensure that the owner of the servient tenement is entitled to develop airspace, etc. I've just been doing some work on airspace over the weekend, again BSA related, but one of the issues that I've been reading about and learning and reminding myself about is airspace development in connection with leasehold flats and apartments. And there's quite a lot of case law that says a landlord is entitled to develop airspace unless there is provision in the lease that specifically excludes it. So where a landlord owns the roof void and airspace above it, a landlord can carry out development. And there's quite a bit of case law where leaseholders have challenged airspace development on the basis that it interferes with quiet enjoyment and interferes with derogation from grant. And there's loads of cases on it which say, well, no, that's not the case. You know, a reasonable development will involve some disruption, but that disruption isn't necessarily sufficient to constitute a breach of quiet enjoyment or a breach of derogation from grant. The only case I've found where a leaseholder has successfully blocked airspace development was a case where the leaseholder was saying that the airspace development impacted on their right to light. There's a book on airspace development written by a barrister, I think he's called Daniel or David Getty. Really interesting book, actually. I've just read it and useful. So watch out for airspace development and really watch out if you're doing BSA related work, because you might have a building that's not a relevant building or a higher risk building. It doesn't meet the height requirement, but that's not to stop a developer from building upwards at some point later in the day. And there was an interesting article in the Estates Gazette last week. If you're acting for commercial tenants in a building that is governed by the Building Safety Act, where you're wanting to carry out alterations, there's a whole raft of additional duties and responsibilities that are imposed on you relating to building safety issues concerning your alterations. So you do need to think about making sure the leaseholder, the tenant, is aware of the fact that there could be BSA issues in addition to landlord's consent issues relating to alterations. Going back to car parking, remember that if you have a right to a right of way across land, there is a case that says the right of way will include a right to park where you have no parking facilities on the land that you own that is the dominant land in connection with the easement. And the other point with regard to car parking easements, you can't claim adverse possession over land that you have an easement over as well. There is a requirement for your land use to be unequivocal to claim adverse possession. So if you're claiming adverse possession over a car parking space on a driveway, but you have an easement to park on that car parking space, that right of an easement would automatically exclude any adverse possession claim. Sources of funds and AML checks. Again, an interesting question. How far do we go in checking sources of funds? So if a third party is providing funds, do we ask for confirmation as to where they've got the money? And if we do that, would we want to check that they've paid tax on the money that they're now giving or loaning to your client in connection with purchase. In other words, how far would we go? How far would we go with regard to a client that's saying they've saved up out of their income sufficient monies for a deposit or contribution towards the purchase of a property? Just what would we do? And then the next thing I want to talk about is SDLT problems. And this is something, again, I've been working on just recently. How many people, yes, Zara, well, you're not going to like this then. How many people would, if they did an SDLT calculation, show on their file that someone else had verified that calculation, or where you're assessing a relief or surcharge applies or doesn't apply? How many people would make sure that a third party, either within the firm or externally, verifies your conclusion? So I'm really interested in that, because the CQS guidance suggests that's what you do. And I take that to mean that you could ask a colleague to have a look at it. Yes, Sue, exactly. And I think the other important thing, Sue, is that you make sure that there's on your file or case management system some form of evidence as to how you've arrived at your decision. Zara, no, an SDLT calculation may be imprecise, so useful, but there are decisions, tribunal decisions, where calculations, HMRC calculations, have been shown to be wrong. So do be careful. Remember, you can seek specialist advice with regard to complex SDLT issues, and also be aware, yeah, Joe, that's correct. Yeah, 500 plus VAT for advice. Yeah, that seems pretty reasonable, Zara. But you've got to be careful. You've got to have a basic understanding of SDLT. You've got to advise your client as to what your understanding is, given the information you've got when onboarding the client. It's then necessary to revise that as the transaction progresses, where necessary. You've also got to be able to show that you've cross-checked what your calculations were when you're onboarding the client, when you've exchanged contracts, when you're completing. So it's quite an onerous responsibility. And the scary stat that I want to give you is evidently there are 49 different types of relief that are potentially available. 49, I wasn't aware of that. I was aware of about 5 or 6. So it's well worth just having a look and seeing what reliefs and surcharges are out there, and just checking and making sure that you are aware of what they are. You don't have to give advice on them, but you do need to be aware of their existence. That is so, so important. Where mistakes are made, first-time buyer relief. Does your client sign a letter confirming their status? As far as other reliefs are concerned, is a demolished property or a derelict property residential or commercial? Again, quite a lot of guidance on what is a derelict property. Again, caution with regard to large residential properties with extensive or expansive gardens and paddocks, etc. What is garden and what isn't? Yeah, multiple dwelling relief's gone. It's gone, but there's some guidance on it, Zara. I was reading about when you exchange contracts. There's some different measures that apply, so be careful with that. Yeah, 6th of March. Thanks, Lisa. Yeah, so figures have to be, how does this work in a practice at your firm? Right, well, okay. Zara, that's an interesting one. As a sole practitioner, what do you do? Could you have an arrangement with a consultant or another sole practitioner just to check? You can use external advisors. I don't know if anyone's come across a company called Compass, but I think they do that. And that's right, Robert. Yeah, thanks. Completion before the 1st of June can still obtain it. Software tool, possibly, Zara. Possibly. That might be a way around it. I'm not sure. Don't know that. Might get Compass along to talk to us about that, actually. Might be interesting. Might get them along to the next forum, to be honest with you. Okay. Anyone else got any sort of burning topics that they want to talk about? There was a case I was looking at this morning involving an online auction. Interesting one. The online auction particulars included images of houses being built on a site. And the issue was, did those images and reference, albeit remote reference really, to the potential for development, sort of constitute a misrepresentation in circumstances where the site didn't have a hope in hell of getting planning, predominantly due to the fact that the majority of the site was ancient woodland with trees, with tree preservation orders. So the court had a look at this and they said, well, first of all, it's important to look at what the seller was aware of. And luckily for the seller in this case, the seller hadn't undertaken any checks to ascertain whether there was any planning potential. The second thing was that the images that were produced showing housing mentioned that this was not, these were drawings, and that no one had consulted with planning about the potential for planning. But the buyer buys and says, I was misled because of those drawings and because there was reference to the potential for development, albeit it was remote. And there was another case, wasn't there, in the past where, remember, the judge said, well, because this is an online sale, there's a likelihood that the buyer would be unrepresented. And therefore, it was incumbent on the auctioneers to disclose problems with title so that an unrepresented client could understand the significance of that. And I think in that case, the court held that the failure to notify that there was a defect in title, I think it was overage, wasn't it? That there was an existence of overage in the particulars meant that that was a misrepresentation. In this case, the court said no. Because the seller wasn't aware that there was no chance of planning, they hadn't investigated. And the fact that the buyer hadn't done his searches, etc., again, wasn't anything that would enable the buyer to rely on the agent's particulars. And the judge said the agent's particulars were such that any reasonable person would not think that that site had planning or had any potential for planning. Right, Zara, interesting. So it's come to your attention that service charge on new builds are purposely being undervalued so as to be able to sell properties. So what developers are doing, Zara, is they're providing service charge estimates, but underestimating what those estimates are in an effort to sell. Is that, am I right in thinking that, Zara? Yeah, okay, right. So an issue. Well, Zara, what I always say to practitioners is, and this is the same, when you're acting for a seller and you're buying a lease, you're acting for a buyer and you're buying a leasehold property, you've got to tell your buyer client, one, that the client is committing contractually to unascertained and unascertainable future expense. You don't know what service charge would be or could be. Secondly, where service charge estimates are provided or 3-year service charge accounts provided by a seller, these cannot be an indicator as to what service charge will be going forward. So I think, Zara, if you adopt that strategy, then you're not, you're dealing with the potential vulnerability of a claim, even on new builds, but it's still worth clients just being aware of, perhaps in a line or two, of that risk. Okay, we're running out of time. I think it's just about 2:30 now. So what I'm going to do is skip through some slides. Next time, remember, any topics or issues, drop me a note to my email address or drop Robert a note. Robert's contact details are on there. A massive thank you to Simon and SNC for coming along today. Again, I'll just go back to show you the contact details as to how to join the SLC. Do speak to Anya or Simon, both lovely people. You've got Robert's contact details on there. Bit of advertising. The book is now out, I'm told. Don't worry, Zara. I'll tell you if it is or it isn't. I'll drop you an email. We are in association with Stewart Title undertaking a load of different conferences up and down the country. Next one is Ashford in Kent. Then we've got Bristol. Then we've got Birmingham. So do come along to those if you'd like to. That would be brilliant. And do have a look at Property Law UK. Comes out last Wednesday of every month. Loads of interesting stuff. We've got 7 case reports on resi cases, commercial cases, loads and loads of articles as well. Right. Lynn, hi Lynn, sorry about this. What does everyone think about the guidance? Yeah, I've seen this. Sellers having to provide a whole range of material information, tree preservations, speeding up matters. It is, I think, a variation on the old home information pack, Lynn. What does everybody else think? Yeah, Zara says bonkers. Zara, I always like it when you shoot from the hip, and that's exactly what you've done there. What about everybody else?
Ian, I'm just going to chip in there.
Yeah, go on, Zara.
Because it's not going to help anything if, you know, we're having to pay for information packs and that out of date within the first 6 months. It's going to cost sellers a lot. Are they now saying that sellers need to do searches? I used to work for a firm that won't accept searches from other people. They're going to be out of date quickly, and especially if you're trying to sell a flat, they're expecting sellers to know or have information about remediation works that are being undertaken by landlords.
Not going to happen.
You know, it's the questions are not easy for a layperson to understand. And they're now saying that they want agents to deal with all of this. Yes, under the guidance of a solicitor, but basically, you know, it's only going to benefit those who already have existing referral fees with estate agents, because that's, you know, the first thought is to go to an estate agent, not to a solicitor to sell your property.
Yeah, there's a number of points that Zara makes there that I'd like to distill just before we finish. The first point is this, that the concept of upfront information is brilliant, assuming 3 things. 1, that it's reliable. 2, that it won't be out of date. And 3, it precludes or means it's unnecessary for the conveyancer or solicitor for the buyer having to do their own searches and making their own inquiries. Okay, so like Lynn was saying, it's going to speed up matters. It will only speed up matters if the information is accurate and up to date, if the conveyancing transaction can progress at speed so that it doesn't come out of date, and if the information that's produced is going to be in a form and accessible to buyers. And I think we ain't anywhere near any of those 3 things, and therefore all we've got is Home Information Packs Mark II. Again, Lynn, Zara, I've got your opinions there. Anybody else just before we finish? It sounds great, okay? But at the moment, it wouldn't work. You know, a buyer's conveyancer is going to say, no, thanks very much. In order to fulfill my duties to my client, I need to do my searches. Okay. As far as inquiries are concerned, etc., we're going to use CQS require with any additional inquiries I feel are necessary. And from as Zara touched on, you know, from an estate agent's perspective, producing this information, how on earth can they produce it in any meaningful way unless a solicitor has looked at it? When is it effective from? I don't know. It's already out, says Jaspreet. But is it live, Zara? I thought it wasn't. Yeah, there's no. You're not obliged to comply, are you? Agents are, aren't they? But we're not. Is that right?
Yeah, so basically there's a group of people made up of the home buying and selling group that want this to start now, but it's not, it's only enforced by national trading standards. It's not in legislation. So the agents that I've spoken to have basically said we're going to ignore this and then put on the right move and Zoopla listings, refer to agent.
Yeah.
And they're happy to take the fine. But there are those like the Conveyancing Association that are pushing for it to go to legislation.
Right. Thank you for that, Zara. Thanks very much. Well, on that note, ladies and gentlemen, thank you again. I've really enjoyed it today. If anyone wants to look at those cases, drop me a note. If you want to have a look at Property Law UK again, drop me a note and I can make sure you can have a look at it to see if it fits the bill for you. And thanks for coming along today. Really enjoyed it. If you're having a break over Easter, then I hope you have a lovely time. Everybody else, stay safe and we'll speak soon. Thanks, Sue. Thanks, everyone. Thanks, Robert. Thanks, Simon. Really enjoyed it. Take care, everyone. Bye-bye. Bye-bye.